This is Professor Wes Porter. This is the Federal Rules of Evidence. This is an introduction video, and this has to do with proponents versus opponents. I think in law school and orienting new lawyers, we talk about plaintiffs and defendants. We talk about appellees and appellants. And evidence, you really got to think about the parties in a distinct way, and that is there's a proponent and there's an opponent. And there's a real easy way, if you ever walked into a courtroom, to tell. The proponent, beginning with a P, is always the one standing up, always the one presenting, putting on evidence. They're the one doing stuff at the time. The opponent is the one on the opposing side of the case, the one charged with objecting at the time. So to put it very simply, in a simple analogy, is this is a criminal case, let's say. The woman on the left side of the photograph represents the government in a criminal case for burglary of a convenience store, and she's questioning the owner of the convenience store at the time. She's the proponent of the evidence. It doesn't matter that she's a prosecution. It doesn't matter if she's a plaintiff in the case. What matters is she's the one asking questions on direct examination, or maybe even trying to admit an exhibit through the store owner at that time. She's the one up doing something. When she sits down and she says, we have no further questions for this witness, and the gentleman stands up and starts his cross-examination, he turns into the one presenting evidence, the one putting on evidence. He turns into the proponent, and she's charged with objecting. So it goes with the course of trial. Who's ever up doing something is the proponent. And the way you got to think about the proponents and opponents as it relates to the rules of evidence is, while she's asking questions and trying to put in evidence through this victim witness, the opponent sits there and he's charged with objecting under the Federal Rules of Evidence. He's the one that's truly patrolling whether what's going on in court is acceptable and appropriate. And so at some point in open court, he stands up and he says objection and offers an evidentiary basis for that objection. Objection irrelevant, objection improper character, objection improper impeachment. He offers some sort of the word objection and then some code words to say, here's the actual article of the Federal Rules of Evidence, here's the actual basis that I have for that objection. They often make their way over to exactly where this photo takes place. This is some kind of sidebar. You see the judge with the robe sitting up there. You see the court reporter taking notes of the sidebar. That's where this is. This is outside of the ears of the jury. And we would go over to sidebar, and at that point, we would go over with the objection that was offered by the opponent. Objection, hearsay. Then we'd go over, and the proponent would say, this is not hearsay because, and they would offer an evidentiary argument to say, this is not what you say it is. This does not violate the rules. This is not improper, and I should be allowed to go forward with my questions. And even at sidebar, the opponent would have the opportunity to further his objection to say, it is hearsay, and let me explain the basis that I offered. Let me explain why it violates hearsay, and the court should not allow it, and should tell me that the objection is sustained and that she should have to move on to some other question. So the dance is objection and basis in open court. Usually at sidebar, the proponent's going to respond and say why this objection should be overruled, why the evidence should be allowed to proceed. The opponent's also going to have an opportunity to explain. Usually goes opponent, then proponent, and then back to the opponent to say, I said objection hearsay, and here's why I think that it violates the rule of hearsay. Here's why it violates Article 8, or no exception applies under the hearsay rules that we'll talk about in different videos. So it's important to understand, as you see in TV and the movies, the opponent stands up and says, objection, hearsay, objection, irrelevant. And they go to this place, sidebar, to talk about what's appropriate for the jury to hear outside of the jury's ears. And usually the proponent responds next, and then the opponent expands upon his objection, and then the court rules at sidebar, and they go back and they ask their next question. Another way to think about, in context of that third question that we talked about, the evidentiary argument, what's going on in this evidentiary argument when the opponent stands up, no matter who that is in the trial, no matter what stage of trial, when the opponent stands up and says objection and offers a basis, objection irrelevant, objection improper character, objection hearsay, what they're really saying is, Judge, let me tell you what the proponent's trying to do here. let me tell you what she's trying to prove and why that violates one of the rules. That's essentially what's underlying almost all of the objections. Let me tell you what she's really trying to do here. And the proponent, you can almost picture it with an innocent face and two hands up in the air and say, that's not what I'm trying to do. That's not what I'm trying to prove. I have some other pathway. I have some other thing that I'm trying to do. That's perfectly acceptable. That's allowed under the rules. So the evidentiary argument, the proponents and opponents often come down to this argument, this third most important question. What is the proponent trying to do? What is the proponent trying to prove? And just imagine that underlying the objection basis in open court goes to sidebar. The proponent says, this is not objectionable. You should overrule this objection. You should allow me to continue with my questions. You should allow me to admit the evidence. It goes back to the opponent, and the opponent says, you should sustain my objection, and you should exclude this evidence. You should cut off these questions and not allow her to continue down this line of questioning. So you can see the back and forth that happens. Opponent first, then proponent, then back to the opponent, the judge rules, and all of it, underlying all of it, comes down to what is the proponent trying to prove? What is she trying to do with this evidence?